Hello and welcome back to this channel. It is Friday. We made it. Friday, and we are not going to waste any time because there are some things to get into. You feel me? Okay, yes, Vanzan has re-entered the docket in the Stephanie motherfucking Jones case against Jennifer Abel and the Wayfarer people. But grab your emotional support lip gloss because this story does not have a happy ending. Blake Lively is over there in her case with Lively versus Wayfarer. We'll go over that real quick as well. And then we're going to go over some of your comments from the week. So if you're ready, I'm ready. Let's go. You are in frame with Mandy Magnan. Y'all, I'm going to tell you right now, I was going back and forth like how to bring you this information because I am peed off, okay? Like peed off because to me, it's not making sense. And when I'm telling y'all this entire time, I was never on the side that the judge was biased, that Ryan Reynolds had bought him, that he was in their pockets. Didn't believe it. I was like, he's a federal judge. There's no way. Although I didn't agree with a lot of his calls, of course. That big dismissal against New York Times, Leslie Sloan and Ryan Reynolds, obviously didn't agree, obviously did not freaking agree. But I was like, Blake Lively's the victim. He's a federal judge. He's going now? After today? It almost seems like maybe because he can't afford to give Lively her attorney fees and triple damages, he's found another way to do it. I am peed off. And Ryan Reynolds, let me tell you something. You might have the judge on your side, but the people are not. We will never forget what you and your wife did when you used your inactive company, Vanzan, to create a fake lawsuit in order to obtain a sham subpoena to get otherwise illegal text messages to plant in the New York Times story and your CRD complaint. You're shady, you're gross, and you did it all to completely damage and ruin and attack innocent people. And on top of that, using the Me Too movement to do it. Shame on you. We will not forget, even though the judge seems to be a little bit less forgiving than we are. Okay. Let's just start from the beginning. I'm going to show you the court docket, and then we're going to go through everything. But we're going to go very detailed, okay? Because I want to look at the times. I want to see how the emails were sent, what the times was. Because how is the judge coming back like that over a ruling? Some of these things I read late last night. Some of them I haven't read yet. So it'll be a little bit of an adventure together, okay? But there are some shadiness going on, and we're going to talk about it. Let's start with Vanzan because I'm literally, guys, I'm still at a loss for words. And what's so funny is I already taped like that whole beginning kind of thing in a way, but then my mic wasn't working. My mic wasn't plugged in, so I lost all the sound on it. And now they started construction like above me, and I was like, maybe it's not meant to be. But nothing is going to stop me from being here today and exposing this and talking truth. And literally at this point, I think the Wayfarer people, they need to appeal. They need to do something. They need to fight back because this ruling on top of the dismissals from the other parties, clock it. It's something fishy. Something fishy's going on. So here we have, this is where it started. We have a motion to compel Vanzan Inc. It was to designate a witness prepared to testify about the full period of its relationship with plaintiffs Stephanie Jones and Jones Works. Then we have the declaration by Kevin Fritz, which we will look at. There's a whole bunch of attachments, which are like the meeting confers, the emails back and forth, and we have a few exhibits that I was able to look at. Then you have already, bang, right away, a letter response in opposition to the motion addressed to Judge Lyman, and that is from the lawyers at Vanzan. They were quick on it, okay? Quick on it. Then you have the declaration from that lawyer as well from Vanzan. Then you have a letter motion to leave a filed reply. This is from Wayfarer. They replied, okay, explaining the situation to Judge Lyman. But Judge Lyman was like, nah, I've decided. You know what? I slept on it. I woke up early this morning. I called Vanzan. I was able to work it out with Ryan Reynolds, and your motion is denied. I mean, that's not what it says, but that's what it kind of seems like. You feel me? And I know maybe there's going to be some lawyers coming on here who are going to be a little bit less emotional and explain it to y'all and be like, no, it was the right call. It was this, it was that. Not here, okay? I've been fighting so hard to figure out what the frick happened with Stephanie motherfucking Jones and Vanzan since the beginning, okay? Since the beginning. So this is just, okay, let's just go. This is the first letter filed last night from Kevin Fritz. And it says, in connection with the deposition set for September 30th, defendants Jennifer Abel, Melissa Nathan, Justin Baldoni, and Wayfair Studios, LLC, collectively, the Wayfair parties, move pursuant to Rules 1C and 4C of Your Honor's Individual Practices and Rule 45 of the Federal Rules of Civil Procedure for an order compelling non-party Vanzan Inc. to designate a witness prepared to testify about the full period of its relationships with plaintiff Stephanie Jones and Jones Works LLC. As set forth herein, Vanzan is attempting to curtail its testimony to admit information the court has already declared is relevant. So once we get into it, you'll see, but Vanzan pretty much only wants to testify from the date that the subpoena was filed. Well, what freaking good is that? They want to know about your communications between Lively, Leslie Sloan, Ryan Reynolds, and Stephanie motherfucking Jones that led up to y'all thinking that you can just get a subpoena that has nothing to do with this CRD action and then use it against them, right? So like they want to know what happened before that, which is what we all want to know because it's unethical, it's immoral, and it's illegal, in my opinion. Rule 26 provides that any parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering, among other things, the party's relative access to relative information. Rule 26 further provides that information within this scope of discovery need not be admissible in evidence to be discoverable. Ms. Abel's counterclaims allege that in August of 2024, just prior to her scheduled departure from Jones Works, the Jones party seized her cellular phone, accessed her contents, and downloaded them. The counterclaims further allege that Stephanie Jones disclosed at least some of Ms. Abel's private communications to the Lively parties no later than August 21st, 2024. Remember that, August 21st, 2024. Continued to access Ms. Abel's private text messages thereafter, and at some point transmitted Ms. Abel's stolen communications to Ms. Lively, her husband Ryan Reynolds, and Leslie Sloan, Ms. Lively's publicist, to harm Ms. Abel. That is exactly what happened. The texts don't lie. The phone call, the phone records don't lie. The way the subpoena and the fake lawsuit from Vanzan don't lie, okay? Ms. Abel also alleges that Ms. Lively conspired with the Jones party to obtain Ms. Abel's stolen data under the guise of legal process. On September 27th, tomorrow, Vanzan Day, on September 27th, Ms. Lively used her company Vanzan to file a lawsuit in New York, in the New York State Supreme Court against Doe defendants, the Vanzan lawsuit. The complaint in the Vanzan lawsuit alleges that the Doe defendants, the identities of whom are unknown to Vanzan, breached unspecified obligations via unspecified oral promises and or unspecified written agreements. Days after the Vanzan lawsuit was commenced, Vanzan issued a subpoena therein to the Jones parties demanding the production of documents pertaining to the film It Ends With Us. Miss Lively, Mr. Reynolds, and sexual harassment and retaliation in connection with the production of the film, none of which are even remotely referred to in the complaint filed in the Vanzan lawsuit. The Jones parties then handed over Miss Abel's communications to Vanzan. Subsequently, the Vanzan lawsuit was discontinued in December of 2024. The same month, Miss Lively included those communications in her pleading. I will go a step further and say it was only 2 days before, I think. I'll have to relook it up, but I believe it was just 1 or 2 days before the CRD complaint was filed, okay? In late June 2025, Ms. Abel filed a motion to compel Vanzan to produce certain documents in response to a subpoena. In a memorandum and order dated July 7th, the court properly determined that communications between Vanzan and or its counsel and the Jones party and or their counsel concerning the Vanzan lawsuit are relevant. Specifically, the court noted that the statutes under which Ms. Abel brings her claims prohibit both obtaining and disclosing protected information. The court correctly stated, this is from Judge Lyman himself, communications between Vanzan and or its counsel and Jones Works and or their counsel concerning the Vanzan lawsuit are likely to bear on or lead to further information regarding whether and when Jones obtained relevant communications and disclosed them to Vanzan or Lively. So he's already ruled on this, okay? The Wayfair party's deposition subpoena, as amended, the subpoena, commands Vanzan to produce a witness who can testify about enumerated topics, including the ownership and management of Vanzan, Vanzan's communications with the Jones parties, the subpoena issued in the Vanzan lawsuit, communications with Miss Lively related to that subpoena, and Vanzan's search for relevant documents. To the extent that topics number 4 and 5 could be construed as overly broad, the Wayfair parties have agreed to A, narrow topic number 4 to Jennifer Abel's counterclaims in the action and the defense thereto, and B, narrow topic number 5 to Blake Lively's allegations in paragraph 10 of her second amended complaint that she obtained the communications cited in her pleadings in connection with a lawful subpoena. And let's not forget that Stephanie motherfucking Jones said almost a dozen times in her complaint that it was lawful, it was lawful, it was lawful, it was lawful. I mean, I guess if you keep saying it enough times, they think it becomes fact. Nonetheless, Vanzan is refusing to provide a witness who can testify at a deposition about such communications and the related topics. According to its written objects to the subpoena, Vanzan will only provide information for each of the topics starting from on or about the filing date of the Vanzan lawsuit, which is September 27th, 2024. Subject to that unreasonable limitation, Vanzan stated that it would designate a Rule 30b-6 witness reasonably prepared to testify about non-privileged information in response to these topics. Stated differently, Vanzan only agrees to produce a witness to testify about what happened after the Vanzan lawsuit was commenced, but not before it was filed. And if you can see my notes here when I was reading it, I was like, what the F? WTF? Because what is going on with Vanzan? Even though the communications between Vanzan and the Jones parties or their respective representatives concerning the contents of Jennifer Abel's electronic data seized by the Jones parties and subsequently delivered to Blake Lively through Vanzan is highly relevant to Miss Abel's counterclaims against the Jones parties, and even though such communications surely occurred before the Vanzan lawsuit was filed on September 27th, Vanzan is refusing to designate a witness prepared to testify about the foregoing. Vanzan argues that the information sought is obtainable from other sources. However, as the court stated in its memorandum and order, there is no per se rule that party sources must be exhausted before documents and subpoenaed from third parties. Putting aside that no other witness has testified about most of the topics, even if such cumulative testimony existed, the Wayfair parties are entitled to test what witnesses to the same events have to say and whether they contradict or corroborate each other. Duh. There is no undue burden imposed upon Vanzan. The corporation has known for months, and certainly since June of 2025 when Miss Abel moved to compel its compliance with the document subpoena, that it was in possession of information material and relevant to the claims and defenses herein. Furthermore, Given the allegations in the counterclaims, the relevant period is not expansive, although the subpoena defines the relevant time period as January 1st, 2022 to the present. The Wayfair parties agreed to limit the relevant time period to July 1st, 2024 through December 31st, 2024. The subpoena was initially issued on September 9th, 2025, and noticed the deposition for September 29th, 2025, which was later adjourned to September 30th, 2025, a period of 20 days for compliance, which is more than the 14 days that courts in this circuit have found to be presumptively reasonable. Therefore, the Wayfair parties respectfully request that the court issue an order compelling Vanzan to designate a witness prepared to testify at deposition about the full extent of the relationship between Vanzan and the Jones parties, including the period before the Vanzan lawsuit was filed. In the event the court grants this application after Vanzan's deposition commences on September 30th, the Wayfair parties respectfully request that the court direct Vanzan to designate an appropriate witness to appear for a deposition consistent with the court's ruling concerning the topics during the first 2 weeks of October 2025. Makes sense, right? Why would they send a representative who isn't willing to testify about any of the time period since before? I would have questions as to why Blake Lively put her name down as the CEO. I would have questions as why is an inactive company that hasn't been used since 2018 or 2019 using this company to file a sham subpoena and a fake lawsuit. I would have a lot of questions for Vanzan that happened before the sham subpoena got filed. Surely they should be aware of that, right? Next we have the declaration from Kevin Fritz. This is concerning, of course, the Vanzan. So this is a declaration in support of the motion to compel. Just says that he is Kevin Fritz and he hereby declares all of the people that he's working for, the Wayfair people. I submit this declaration in support of the Wayfair party's motion to compel Vanzan to designate a witness prepared to testify at deposition about the topics set forth in a subpoena served by the Wayfair parties. The deposition of Vanzan's representative, who has not yet been identified by Vanzan, is scheduled for September 30th at 10 a.m. Why I think that's important is they don't even know who's gonna represent Vanzan and who does represent Vanzan. Who is Vanzan? Because as far as we know, it was an inactive shell company that Ryan Reynolds had in Delaware, and the only thing that was ordered was furniture for a Taylor Swift music video, allegedly. They've only done one thing, and it was back in 2018, 2019. Okay, so who is it? Anyway, they haven't even noticed. And something that's important there is because remember when Blake Lively was supposed to be deposed, not the first, not the second, but the third time when she finally sat her butt down in that chair, she made a big hoorah about not only the deposition address, but she needed to know who was going to be there. All the defendants have a right to be there. But the fact that Vanzan hasn't even said who's supposed to be going there on the 30th, which is just in a few days. Anyway, they continue on, and probably one of my favorite things that's written in this entire thing that made me chuckle was the footnote, okay? Mr. Reynolds is the husband of Blake Lively. Just so we're all clear, yeah, he's the husband to Blake Lively, okay? I just thought that was really funny because they had to explain who Ryan Reynolds is. Ryan Reynolds is the husband of Blake Lively. According to, they could have wrote oh, he's an actor, he's an entrepreneur, he's this, he's that, he's that. He's the husband of Blake Lively. According to biennial statement filed with the New York State Department of State Division of Corporations on June 30th, 2025, the chief executive officer of Vanzan is Ryan Reynolds. A true copy of the biennial statement is attached as Exhibit A. True excerpts from the transcript of the deposition of Blake Lively, conducted on July 31st, 2025, are attached as Exhibit B. A true copy of the complaint filed by Vanzan and against Does 1 through 10 in the Supreme Court of New York, attached as Exhibit C. A true copy of a subpoena issued by Vanzan to Stephanie motherfucking Jones and Jones Works in the Vanzan lawsuit is attached as Exhibit D. a true copy of a notice of discontinuance filed by Vanzan in the Vanzan lawsuit on December 19th. So it was December 19th, just the day before, okay, is attached as Exhibit E. According to the docket from the Vanzan lawsuit, a true copy of which is attached as Exhibit F, Vanzan did not file a request for judicial intervention and no judge was assigned to the case. And I looked into it, guys, because I was like, that's kind of interesting, because what does that mean? Like, they didn't ask for a judge, no judge was assigned, and they didn't request a judicial intervention. Well, oh my, just shows you. From what I've learned here in New York and other jurisdictions, if you file a lawsuit, it doesn't automatically get assigned to a judge. A party has to file a request for judicial intervention to bring a judge into the case. So without filing that request for judicial intervention, the case just sits in the clerk system for as long as it needs to, with no judge actively managing it. But when you file the RJI, the request for judicial intervention, it signals that a party wants the court to take action, hear motions, schedule conferences, etc., etc., etc. With Vanzan, Ms. Blake Lively and Ryan Reynolds not actually asking for the IRJ, it literally means that they knew that they didn't want any action to be done with the case. In my opinion, it seems like without them asking for the IRJ, which we all know, they knew that it was a fake lawsuit. They didn't want it being moved in the courts. They didn't want a judge assigned to it. They wanted it to just sit there stagnant until they can pull it after they get all of the records that they needed. Therefore, the Vanzan lawsuit, which they were able to get a sham subpoena with, they knew that it was just going to sit there, and they did not want it to proceed to any hearing or trial. What does that tell you about the lawsuit? They weren't looking for active litigation with that fake lawsuit. No, all they wanted to do was be able to get a sham subpoena in order to use otherwise illegal text messages from a personal device from Jennifer Abel, as well as everything that they tried with Vanzan, everything that they put in there for Stephanie motherfucking Jones had nothing to do with Wayfair. It ends with us. Nothing like that. Sexual harassment. From what I'm reading here, you don't really need a judge in order to get a subpoena. Just because they filed the lawsuit, okay, their attorney is able to then use that to use that lawsuit on their own authority as officers of the court to then file their own subpoena. Oh, wow. And I'm just reading it here, and it says the court system allows attorneys to compel discovery or witnesses without judicial involvement unless there's an objection. Well, of course, there was no objection. Stephanie motherfucking Jones could have objected. She could have done anything. She could have let Wayfair know. She could have done nothing. And she could have done something. But instead, she did nothing. She handed it all over. And why is that? Because they were already in communication and working together. But Vanzan, no. They don't want to talk about that. They don't want to talk about what happened before September 27th. Of course not. Whew, I'm fired up, guys. Okay, we continue. Okay, I'm so sorry. This might be a long one, okay, because we're just going into it. Whew, I'm fired up. No words. Okay. There you go. So I'm fired up. I'm fired up about this because this is some of the shadiest things I've ever seen. But we continue, okay? So yes, they did not ask for a judicial intervention and no judge was assigned to the case. On September 9th, the Wayfair parties issued the subpoena to Vanzan, which commanded a representative of Vanzan to appear for a deposition on September 29th. And B, the production of documents. A true copy of the subpoena dated September 9th is attached. On September 11th, Vanzan's counsel accepted service of the subpoena. On September 18th, the Wayfair Party's counsel and Vanzan's counsel agreed that the deposition would be held on September 30th. Accordingly, on September 18th, the Wayfair Parties issued an amended subpoena containing the September 30th date for the deposition. So they didn't do anything. They didn't change anything. They didn't ask for anything extra. They just sent the revised subpoena for the right date. So instead of it now being on September 29th, they sent one for September 30th. In the footnotes here, it even says the Wayfair parties are not seeking to compel the production of documents. Okay? They are not seeking to compel the production of documents. They are seeking to have someone come and talk about the relevant topics that they put in the subpoena dated from the beginning of summer of 2024. The topics for which the subpoena seeks deposition testimony are as follows. Lively's direct or indirect ownership interest in Vanzan. Ownership interest in Vanzan. Your managerial structure. The parties' claims, allegations, defenses, and counterclaims in this action. The parties' claims, allegations, defenses, and counterclaims in the action Lively versus Wayfair. Your relationship and communications to Jones. Your relationship and communications with Jones Works. The issuance of and communications relating to the subpoena. Your claims and allegations in Vanzan Inc. versus Doe's 1 through 10, inclusive. Hello, of course you're going to have to talk about all this. Your communications with Lively relating to the subpoena. Your document collection, document search, and document production in this action. On September 22nd, 2025, Kevin Fritz, I met and conferred by telephone with Vanzan's counsel about its objections to the subpoena, including the topics on which the Wayfair parties seek deposition testimony. Vanzan's counsel claimed that the testimony sought could be obtained from a party. When I asked Vanzan's counsel to specify which party, Vanzan's attorney, John Fedoroff, stated that his understanding was that Blake Lively testified about the topics. Now, if this isn't telling you everything you need to know about Ryan Reynolds throwing his wife, Blake Lively, under the bus, whoo-hoo. I mean, that tells you everything you need to know right there. When asked Vanzan's counsel to specify which party, Vanzan's attorney, John Fedoroff, stated that his understanding was that Blake Lively testified about the topics. In response, Kevin Fritz asked counsel if they possess a copy of Miss Lively's deposition transcript, which has been designated confidential under the protective order. Vanzan's other attorney on the call, Margaret O'Donnell, answered, "We're not answering that," or similar words to that effect. Yeah, of course, because it's supposed to be confidential, so why'd y'all have to see it? And why do you think that Blake Lively is going to be talking about everything to do with Vanzan? Huh? Interesting. Miss Lively did not testify about Vanzan except for one sentence. On the evening of September 24th, 2025, Vanzan served its objections and responses to the subpoena. A true copy of the objections is attached as Exhibit I. As you can see in my little footnote here, I wrote, "Bullshit. I read it first." So I actually started last night reading Exhibit I, and I was like peed off. And I was like, what am I reading here? I was so mad just from like the intro. I was like peed off. And then I realized, oh, I was reading it from Vanzan. I kind of read things a little bit backwards, but we're going to get to the exhibit, y'all. In the objections, Vanzan objected to all the topics, alleging that the testimony sought is irrelevant to the claims, defenses, facts, or circumstances related to this action. Furthermore, so they object to all of the topics. All of the topics that the judge had already said was admissible, was relevant. So they object, They object to all the topics. They say is irrelevant to the claims, defenses, facts, or circumstances related to this action. Further, Vanzan stated it will only provide information for each of the topics starting from, on, or about the filing date of the Doe lawsuit being September 27th. Subject to that unreasonable limitation, Vanzan stated that it would designate Rule 30b-6 witness reasonably prepared to testify about non-privileged information responses to these topics. Stated differently, even though the communications between Vanzan and the Jones parties or their respective representatives concerning the contents of Jennifer Abel's electronic data seized by the Jones parties and subsequently delivered to Blake Lively through Vanzan is highly relevant to Miss Abel's counterclaims against the Jones parties. And even though such communications surely occurred before the Vanzan lawsuit was filed on September 27, 2025, Vanzan has refused to designate a witness prepared to testify about the foregoing. Upon receiving the objections, the Wayfair parties agreed via email to A, narrow topic number 4, and B, narrow topic number 5. They'll narrow it, but we need to talk about what happened before. Furthermore, and with respect to Vanzan's relevancy-based objections, the Wayfair parties reminded Vanzan that in its order dated July 7th, from Judge Lyman, y'all. Judge Lyman already ruled on this, okay? July 7th. The court already determined that discovery from Vanzan was relevant to Jennifer Abel's counterclaims against the Jones parties. Given that the Vanzan deposition is scheduled for September 30th, 2025, merely a few days from now, the Wayfair parties asked Vanzan to withdraw its objections to the topics by noon on September 25th, 2025. Vanzan has failed to do so. You would think that then the judge would be like, excuse me, Vanzan, I already made a ruling on this on July 7th, months ago, and yeah, you're going to have to answer those questions because I already ruled on it, and too bad, so sad, right? No. But the response from Vanzan, they responded, let the gaslighting begin. 3, 2, da-da-da-da-da, let's go. And I just want to mention again, the 2 lawyers that Wayfair brought on specialize in not only appeals, but white collar crime. So Vanzan has every reason to be terrified, as they should be. And I just want to go over quickly the timeline that we have already. So on September 25th, last night, at 8:56, the motion to compel was filed. Just moments later at 9:06, the Kevin Fritz declaration that we just went over was filed. This morning at 8:51, the opposition from Vanzan was submitted, which is what we're going to go over right now. Let's count how many times they try to blame this as a PR stunt. Okay. I don't know. How are you guys holding up so far? Because it's just getting started. Okay, here we go. We write on behalf of non-party Vanzan Inc., aka Ryan Reynolds, in response to the letter motion to compel filed by defendants, which purports to compel a corporate representative for Vanzan to testify as to specific time periods in its upcoming Rule 30B deposition as to a certain deposition topics. Who's the representative? Who runs this business? Nobody runs this business except for Blake Lively and Ryan Reynolds because it's not a business. It's a shell inactive company. It was inactive. I digress. This is a curious request, given that Vanzan confirmed on multiple occasions that it was producing a corporate designee on September 30th to testify to all topics in the deposition subpoena. Remember that. Remember that they said that. Okay? Second line. This is and they're so bold that they put it in bold for us. Vanzan confirmed on multiple occasions that it was producing a corporate designee on September 30th to testify to all topics in the deposition subpoena. Clock that, okay? Second sentence. We're going to go over it after. This letter motion is either an effort by defendants to use the court's dockets to advance an unfounded narrative and generate media coverage around Vanzan, a frequent boogeyman of defendants. Is it a boogeyman? Vanzan's a boogeyman? A boogeyman? Y'all are the ones that use the courts to sum up a fake lawsuit. It's absolutely ridiculous. Anyway, or an attempt to manufacture a dispute where none exists. Regardless, defendant's motion does nothing more than waste the time of the court, the parties, and third-party Vanzan. Unless ordered otherwise, Vanzan plans to produce its corporate designee to be questioned on the subpoena topics on September 30th and told defendants that in writing on multiple occasions before they filed this baseless motion. Accordingly, there is nothing for this court to compel, and the motion should be denied as moot. With respect to the narrow issue defendant's motion raises, which is Vanzan's objections regarding the relevant date range of certain topics, they never once raised or conferred with Vanzan on the issue, nor has Vanzan ever refused to provide testimony on any of the topics set forth in the subpoena. Okay? Nor has Vanzan ever refused to provide testimony on any of the topics set forth in the subpoena. That kind of sounds like the same thing up here in bold, where it says that they're going to send someone to testify on all the topics, right? Okay, that's great then. Then what's the problem? You said you've never refused. That's perfect. Upon receiving their motion, we ask counsel for defendants to withdraw their motion to compel because there is no dispute and therefore nothing to compel. They refused, but instead demanded that all objections be waived, including privilege. But you just said that you had no objections. It literally just says right at the top, nor has Vanzan ever refused to provide testimony on any of the topics set forth, but then at the bottom said that they want to have the objections waived. Well, if you don't have any refusal, then why are there even objections to be waived? I don't know. In my opinion, it just seems a little bit like wordy and a little, a little weird wording. There is no issue for this court to resolve. There is no issue for this court to resolve and no need for defendants to waste the court's resources with this motion. A review of the relevant events reveals that defendant's motion is without basis. On September 11th, counsel for Vanzan accepted the service of the subpoena. It contained 11 deposition topics and 12 new document requests. Defendant's sprawling subpoena sought discovery on a wide variety of topics. At no point did defendants ask for a meet and confer in advance of serving the subpoena or following service of the subpoena. On September 18th, counsel for Vanzan asked to meet and confer with defendants. At the meet and confer, counsel for Vanzan informed defendants that it would produce a designee to testify on the topics and would serve general objections on September 24th. On September 24th, Vanzan served objections and responses. So you served objections, but at the top you just said that you're willing to testify on all topics. So it seems like it's just a little bit of a kind of like a word salad here that's not really matching up. At the end of the objections to each of the specific topics, Vanzan affirmed that it would produce a deponent to testify as to the topics and listed no specific limitations other than privilege. This is in stark contrast to simultaneous objections filed to defendant's document subpoena, where only objections were listed. Vanzan also offered to meet and confer. On September 25th, counsel for defendant sent an email to counsel for Vanzan offering to narrow the topics. Great. Counsel for defendants also demanded that Vanzan respond by noon on Thursday if Vanzan withdraws its objections to the topics. If the objections to the topics are not withdrawn by such date and time, we will seek appropriate relief from the court, which is what Wayfarer did. On September 25th, counsel for Vanzan responded that we need to discuss with our client and expect to get back to you later today or tomorrow morning with respect to the specific issues you raised. In the meantime, confirming we are planning on having a deponent testify on Tuesday. There were no additional emails from defendant's counsel, no phone calls. Defendant's counsel never raised any time period issue, nor did defendant's counsel give counsel for Vanzan the courtesy of consulting with her client. As counsel stated she was doing, defendant's counsel made no effort to apprise counsel for Vanzan on any specific issue relating to the objections. That is in stark contrast to the other specific components of defendant's 12:38 a.m. email, which offered, for example, narrowing of certain topics and a discussion about relevance. As such, it is difficult to see this motion to compel as anything other than an attempt to manufacture a dispute and drag drag non-party Vanzan into litigation for show. You're literally the reason how we got here. Allowing defendants to reiterate their misleading narrative about Vanzan for the press. If defendants had any genuine concerns about the time period objection, they would have raised it with Vanzan before inconveniencing the court. That is the purpose of the meet and confer requirements and consistent with the principles of professional decorum and professional efficiency. Yet at 8:56 p.m. on Saturday, defendants filed a motion to compel Vanzan, which seeks to compel Vanzan to testify to the original time period in the subpoena. Roughly simultaneous to their filing at 9:02, counsel for Vanzan sent an email accepting the proposed narrowing of topics 4.5, providing the names of the designee and the attendees for the deposition, and confirming again that Vanzan would attend deposition. After reviewing defendant's motion, counsel sent defendants emails requesting they withdraw the motion and explaining why. Counsel for defendants responded and refused. Don't you think that timing is a little bit funny? Like 10 minutes after this gets filed in the court, Vanzan responds to Wayfair. Like, to me, it just seems a little, something's not right. Something smelly is getting a little snitchy in here. The motion is an effort to manufacture disputes so defendants can further burden non-party Vanzan and provide more fodder for an ongoing media campaign. What is that, the third time they say it's a media blitz? As defendants know, had Vanzan sought to limit the scope of the topics, it had to file a motion for a protective order with this court. Instead, Vanzan served objections and responses, met and conferred as appropriate, and confirmed multiple times that its designee would testify on the topics. In conclusion, the court should deny defendant's motion as moot. There is no dispute between Vanzan and defendants. As Vanzan has stated to defendants and consistent with federal practice, Vanzan will produce a designee to testify as to non-privileged information regarding the topics without waiving any objection. Okay. Look at these footnotes. Okay, the footnotes are wild. Defendants characterize this as request to compel testimony about the full period of Vanzan's relationships with plaintiffs Stephanie motherfucking Jones and Jones Works. Defendants use their motion as a vehicle to reiterate their baseless claims regarding how evidence of their misconduct was obtained from Miss Abel's phone and their media-friendly theory about the underlying Doe litigation in New York court. How are they able to just like, oh, it was nothing. Oh, it was fine. Oh, we did it lawfully. Oh, there's nothing to see here. Nothing to see here. We're innocent. How are you dragging us into this? Oh my God. Make it make sense. You better explain something because what y'all did was crazy. And you didn't think that you were going to get caught because if you were thinking that it was lawful, you would have used her fucking name, Blake Lively, or Lively Limited, or Blake Lively, her acting company, or her anything, any of her own companies. But no, you didn't, did you? You used a shady, inactive Delaware shell company to file a baseless lawsuit against Jones Works, Does 1 through 10, to obtain illegal material. Guys, and you're just out here acting like what? What you did was fine? What you did was okay? I even did a little F-bomb. Oh my gosh. Okay. Anyway, it continues. Without any evidence that there was a prior relationship between Vanzan and Miss Jones or Jones Works, Vanzan is preparing a deponent to testify about any alleged relationship Vanzan had with Miss Jones and Jones Works as set forth in the relevant topics. Defendants may note that their 12:38 a.m. email had a vague catch-all request that Vanzan withdraw their objections to the topics given the sprawling nature of the defendant's subpoena. Vanzan asserted several standard objections to the topics, including as to relevance, privilege, work product, burden, time period, and overbreadth. So they're saying, remember at the beginning when they were like, yeah, we're fine, we're Gucci, we're going to testify to everything, we're going to send someone, everything's fine, we have no objections, we're good, we're going to be there. Now look, yeah, You weren't. They objected to every single topic. And I'm going to pull it up. These people are just lying through their teeth. I mean, the gaslighting is crazy. In one sentence, they say one thing and then literally are doing something else. Defendants had multiple opportunities to raise any concerns about the time period objection specifically, but never did, and simply demanding that all objections, including privileged objections, be withdrawn is not reasonable or made in good faith. They're playing a real nasty game here, and it just shows you how absolutely corrupt Ryan Reynolds is. It's clear as day. They have everything to hide, and they know it, because why are you fighting so hard? If you had nothing to hide and you were subpoenaed and you have a deposition date, why are y'all still fighting just days before? You don't want to talk about no communications that happened leading up to the SHAM subpoena? Why is that? Answer me that. Why is that, Blake Lively? Why is that Ryan Reynolds? Or wait, guys. Why is that Vanzan? Who's Vanzan? Ryan Reynolds and Blake Lively? Give me a break here. This was the response just an hour later. Kevin Fritz responded to Vanzan. Vanzan's opposition was sent in at 8:51. This is the Wayfarer's response at 10:03. So about an hour and, what are we saying here? 13 minutes or something? I guess that's right. This is the response. I haven't read it yet, but here we are. It's a shorty, okay? In response to each of the 11 deposition topics, the topics enumerated in the subpoena, Vanzan objected on various grounds, including Vanzan will provide information for this topic starting from on or about the filing date of the Doe lawsuit. The Vanzan Inc. versus Doe's 1 through 10 lawsuit was filed on September 27th. Vanzan's response to each of the 11 topics concluded with subject to and without waiver of the foregoing objections and reserving the right to assert additional objections. Vanzan will designate a Federal Rule Civil Procedure 30B6 witness reasonably prepared to testify about non-privileged information responsive to the topic. In other words, Vanzan confirmed that it would only provide information for each of the topics starting from September 27th. And not before such date. Therefore, the following statement in the opposition is inaccurate, nor has Vanzan ever refused to provide testimony on any of the topics set forth in the subpoena. Yo, Kevin Fritz! Yo, if you want to hire me, Wayfair, Brian Freeman, somebody hire me, because I was like, clock it, guys. And I can show you, I literally just downloaded this just now when I said I haven't read it. Here we go. Just downloaded it on my computer. Haven't read it. That's crazy. But exactly. They said Vanzan never refused to provide testimony. But literally in the opposition, because I read the Exhibit I yesterday and I was getting so angry last night when I was reading it. I was like, that's a lie. Because if we're going to look at the exhibit, all they did was object to every single topic. Liar, liar, pants on fire, these people. The Wayfair parties were not obligated to wait and hope that at the deposition on September 30th, which is the last day of fact discovery except for certain matters, Vanzan would withdraw the objection. Upon receiving the formal objections, we asked Vanzan's counsel to withdraw them. Of course, not a privilege-based objection. Of course, like if it's lawyer, if it's, attorney-client, of course not. But all of the other ones, and we're going to go through them, guys. We're going to go through them real quick. Vanzan failed to do so. In the early morning of September 25th, 2025, we asked Vanzan's counsel to meet and confer during the morning business hours of September 25th. Counsel stated it needed to discuss the issue with his client, presumably Blake Lively or Ryan Reynolds. Okay, y'all, at this point, I think Kevin Fritz and I are like twinning. Okay, I think we're twinning. Okay. And would get back to us later that day or the following morning. As of the evening of September 25th, no response was received. Given the looming September 30th deposition, it would have been improper to further delay judicial intervention. Even after the motion was filed and Vanzan seemingly stated it would withdraw its stated refusal to provide information predating its New York State court lawsuit, we asked Vanzan's counsel to prepare a formal stipulation to that effect, which could be so ordered by the court, thereby resolving the motion. Vanzan refused. We also asked Vanzan's counsel for its good faith basis, if one existed, for its refusal to provide information predating the Vanzan lawsuit. No substantive response was received. Notably, Vanzan still has not advised the Wayfair parties which of the listed attendees for the deposition, whom all appear to be attorneys, is the corporate designee and for which topic. To the extent Vanzan is now agreeing to withdraw the time period based objection, the motion should be granted as unopposed. To the extent Vanzan is maintaining such objection, the motion should be granted for the reasons set forth in our initial papers. Right? Kind of makes sense, right, y'all? Like, why would they even want to talk to Vanzan about anything to do prior to that? They want to know how this happened leading up to it, the relationship with Lively and Jonesworks and Vanzan. Duh. It makes sense, right? Here you have Vanzan, aka Ryan Reynolds, aka Blake Lively, aka shady ass immoral lawyers, all up in the courts lying. And what does Judge Lyman do? I'm so sorry to bring this to you, this bad news to you. But the judge, no reason, no reasoning why, no this, no nothing, no that, no big letter, no explanation, just this. The motion to compel is denied for failure to satisfy Rule 4.c of the court's individual practices in civil cases. Vanzan Inc. may move by letter brief for recovery of its expenses, including reasonable attorney fees. What the fuck are you talking about? Even Vanzan, in their letter to oppose, only asked that the court put the motion to compel as moot. They didn't even ask for attorney fees. And now you have Judge Lyman over here saying, yeah, you know what? I'm going to deny the Wayfair people, and also I'm going to give you some money. Who are you giving money to? Vanzan doesn't exist. It's an inactive shell company. You're giving money to Ryan Reynolds and Blake Lively. Why? Wayfair is just literally trying to fight their case. This is the most, this one, I'm telling you right now, I'm not on board with, okay? It doesn't even make any sense. And let me tell you why it doesn't even make any sense. On top of it just being super shady and it doesn't make any sense, and why are you awarding attorney fees and all of this other stuff that they can ask for, which is so crazy. Look at the time. Last night, 9 o'clock was the first motion to compel. 8:56. 9:06, we get Kevin Fritz's declaration. This morning, we get the opposition from Vanzan at 8:51. At 10:03, Wayfair responds. And an hour later, it only took the judge an hour to read all of the documents, all of the emails, all of the stuff. An hour? No. This is smelly. This is snitchy. This is shady. Ain't no way. Because let's look at the court docket one more time. Here it is. I brought it back up. Look at, okay, so just with the declaration from Kevin Fritz, there's all these emails, all these meeting confers, all these attachments. Then you have the same thing from the Wayfair people when they sent in their declaration and they're opposing. Then you have more emails here, these attachments. You're saying in less than 1 hour, the judge was able to lawfully rule on this and allow Vanzan to file for attorney fees and costs. Tell me I'm wrong. I mean, I need someone to explain it to me straight up then, because for me, it's not right. Something's off. Okay? The meat is bad. There's smell in the water. You know what I'm saying? Like, something's not right. Okay. I know I got a little emotional during some of that because it's like, what's going on here? This is the house of cards that we were waiting to crumble, because this is how it all started, and we all know it was so shady and so immoral, and what is going on, right? Okay. But now we do have on the record that Vanzan said they are going to send someone on the 30th, and that they don't oppose any of the topics, right? We remember I was like, clock it. Let's look at some of the responses from Vanzan. And this is why I think this is all being led by Ryan Reynolds. So this was the Vanzan's objection and responses to defendant's subpoena to produce documents and provide testimony. It says on September 11th, Vanzan accepted service of the instant subpoena, which contains 12 requests for production of documents and 11 deposition topics, and request that the depositions be scheduled on September 29th. On September 18th, Vanzan and defendants agreed by email correspondence to hold Vanzan's deposition on September 30th. Okay, then they sent them that new subpoena to reflect the subpoena 30th deposition date. In April, defendant Abel served non-party Vanzan a document subpoena with 11 different requests. Using the original subpoena as a vehicle to deflect from the core issues in this action and related actions, defendant Abel sought a variety of information from Vanzan, which ranged from Vanzan's corporate structure to documents received in an earlier New York State proceeding. An earlier New York State proceeding is exactly how we got here. Okay, they make it seem like what they did was so legit. Like everything that they did through Vanzan in that little New York lawsuit that didn't go nowhere because they didn't file nothing. Oh yeah, it was okay. It was above bar. Defendant Abel offered to withdraw certain subpoena requests and narrow 4 of the remaining 5 requests and produce certain documents. Vanzan's articles of incorporation and written consents of Vanzan's board of directors, which reflect its officers and shareholders, a copy of a subpoena issued by Vanzan in the Doe litigation, and documents produced in response to that subpoena. The granted motion as requested number 9 of the April 21st subpoena. Right, so you already knew that you were going to have to give all of this information up. Consistent with the court's order and the agreement between non-party Vanzan and defendant Abel, Vanzan produced thousands of documents in July of 2025 and completed its document production that month. Defendant Abel did not raise any issues with the production, identify any deficiencies, or file any motions relating to this production. Notably, the court imposed deadline for defendant Abel to file a motion to compel a third party to produce documents was August 22nd. Thus, all issues pertaining to document request to third-party Vanzan were resolved. But as you know, Wayfarer said they're not requesting any new documents. These are the topics that they want to talk about, and they want a representative sent that is going to talk about these topics, and they want it done prior to the September 27th, 2024 date, which is what Vanzan only wants to talk about. Now, disregarding this history, defendants issued the instant subpoena, which contains 12 document requests. The bulk of the requests seek documents in the subpoena which cover identical or similar categories of documents as the April 21st subpoena. The requests on their face are duplicative of the initial request already issued to Vanzan and litigated before the court. The other requests seek documents that have already been produced in this action or documents that are largely protected by various privileges. All the requests seek information that defendants could have sought during the open period for the third-party document discovery. Defendants are also violating this court's scheduling order for discovery. On July 15th, the court ordered that the date for completion of all document discovery, including production by non-parties pursuant to the subpoena and responses to requests not yet issued, is extended to August 15th. Okay, they're not asking for anything. Then they say, okay, so then they go on about the scheduling and how it's past the deadline. So since it's past the deadline, they're not going to give any new production. Okay, they got what they got and that's it. There is no justification or good cause for the delay in issuing these new requests. Moreover, the untimely service of these requests only 2 weeks from the close of discovery and not only 2 weeks from the requested deposition date impose a significant burden on non-party Vanzan. To which I wrote, ugh, that's a crazy note. What effing burden, beach? You said the documents are identical. What are you hiding? That's the note I had, I guess, when I was reading that. Anyway, so they go on to say what their objections are to all of the new topics. They say that it is no way an admission of guilt. Vanzan makes the following objections and responses based upon documents within Vanzan's possession. Vanzan's responses do not imply any agreement or concession that the documents requested are relevant and or admissible in this or any proceeding, and the responses are not to be construed as waiving any objection stated herein or as waiving any objection on any ground to the use of the information within them in this or in any other proceeding. They are so scared. I wrote that in the note because I'm like, what are they hiding? Any inadvertent disclosure by Vanzan or documents or information protected by the attorney-client privilege, the work product doctrine, the common interest doctrine, or any other applicable privilege shall not constitute a waiver of that privilege or doctrine. So they're just saying, hey, just in case we gave you any of the papers that have to do with that stuff, yeah, can you just like tear them up and not talk about it? Because, you know, you shouldn't have them. So then we just go into all of their objections, right? And if you look, okay, we're going to get into it. We're going to get into the objections, but they object to every single one. Vanzan objects, Vanzan objects, Vanzan objects, okay, to every single request that they ask for. They have objected to every single thing. And I found some of them quite interesting. For the most part, it's the exact same thing over and over and over, that they just object because it's unduly burdensome and it's not like part of the case, etc. But this one is kind of interesting. Vanzan objects to the definition of lively in the request and topics, which is overbroad because it includes unnamed and unknown individuals who presently act on Blake Lively's behalf. Vanzan interprets the term lively in the request and topics so as to make the request and topics reasonably intelligent, meaning the physical person, Blake Lively. But yet, when Blake Lively was asking him to search all of the terms, not once, not twice, she asked for so much stuff and then kept going back and compelling more and compelling more. They even had them searching for search terms that had the word affair in them. Y'all remember that? If I have to, I'll try and pull it up. I'll try to find it. But I remember that. They had to like pull up search terms with affair in them. And they don't want to look for search terms with lively. Anyway, as you can see, it objects, they object to everything. They object about Jones' works, they object to everything. Vanzan objects, so even this topic, Lively's direct or indirect ownership in Vanzan. Vanzan objects to this topic as irrelevant, not proportional to the needs of the case, overly broad, vague, ambiguous, and duplicative. Well, no, I mean, it's definitely involved. Does she even run Vanzan, or did she just put her name on it in order to use it to file this fake lawsuit? And then it does say that they're not going to do any relevant time between January 1st of 2022, but they'll be okay, and they'll talk to you about from the filing date of the Doe lawsuit. My gosh. Then there's this. Then they say some of the stuff is unintelligible, given that it requests information about lively direct or indirect ownership interest without defining direct, indirect, or ownership interest. Finally, Vanzan objects because defendants already had an opportunity to seek deposition testimony on this subject, including from Ms. Lively in the Lively versus Wayfair action, subject to and without waiver the foregoing objections. Then they have ownership interest in Vanzan. They object. They object to everything. But then yet, remember in that email, that letter to the court, they're like, we don't object to nothing. Your managerial structure, they object to that. It seeks confidential information, proprietary information, business information, etc., etc. I mean, the entire thing is just, they object to everything. The parties' claims, allegations, defenses, and counterclaims in this action, they object to that because it seeks information subject to the attorney-client privilege. This entire thing is objections. The parties' claims, allegations, defenses, and counterclaims, they object. I mean, we can keep going, but the relationships and communications with Stephanie motherfucking Jones, they objected. They object to, as you can see, every single thing. Then it also, they have here topic number 10, your communications with Lively relating to the subpoena, they object. Because Vanzan objects because defendants already had an opportunity to seek that deposition from Lively. But as Wayfair said, they're still allowed to ask them about it to see if it matches up and if it's okay. But this whole thing is just, honestly, it's just objection, objection, objection. Now we have Exhibit J. This was the first one in the motion to compel filed by the Wayfair people. Let's see. It's an email chain from Vanzan counsel to Wayfair. This was on September 24th at 10:09 p.m. She wrote, "Dear counsel, please find enclosed Vanzan Inc.'s objection and responses to the subpoena served by defendants. We are available for a meet and confer." That's the one that we just looked over, and it was all objections. Very interesting. Maggie here sent that on. Okay, so that was on September 24th at 10:09. And then at September 25th at 12:38, so the next day, Kevin Fritz wrote, "Maggie, we are willing to narrow topic 4 to Jennifer Abel's counterclaims in the action and defendants. We are willing to narrow topic 5 to Blake Lively's allegations in her second amended complaint. As you are aware, in its order dated July 7th, the court already determined that discovery from Vanzan was relevant to Jennifer Abel's counterclaims against Stephanie Jones and Jones Works. Please let me know by noon on Thursday if Vanzan withdraws its objections to the topics. If the objections to the topics are not withdrawn by such date and time, we will seek appropriate relief from the court. In addition to the meet and confer concerning the subpoena that we participated in via Zoom earlier this week, we are available to further meet and confer on September 25th from 9 till noon. Lastly, for security purposes, please provide me by the close of business date with the names of all persons who are attending the deposition of Vanzan's representatives on September 30th. So that was sent by Kevin at 12:38 a.m. So he answered right after her, like at midnight. So she's writing at 10:09 p.m. He's answering just about less than 2 hours after midnight. And then she responds the next morning at 10:30 a.m. with, "Dear Kevin, we received your email from 12:38 a.m. Yeah, okay, so why would you sent it first at 10:09 p.m. He's just answering. Anyway, she starts with that. "We received your email from 10:38 a.m. We need to discuss with our client and expect to get back to you later today or tomorrow morning with respect to the specific issues you raised. In the meantime, confirming we're planning on having a deponent testify on Tuesday." But y'all didn't answer the questions. You didn't answer nothing. Now we have this exhibit that was provided by Vanzan in the email chain. It's kind of all the same thing that we just went over, the first couple emails. Let's look at this. Okay, so this was at 10:28 a.m. She wrote, "We received your email." That's the one that we just read. Then the next email, again, is from Maggie. And this is at what time? Thursday, September 25th at 9:02 p.m. 9:02 p.m. she wrote on September 25th, which is very funny because the motion to compel and everything from the Wayfair people were submitted into the courts at 9:06. Something is fishy about that, if you ask me. Or maybe just really good timing. Who knows? But this is the email response that they sent just moments after the Wayfair went to the courts. And it says, "Thanks for your email. We accept your proposal to narrow topics 4 and 5 for the Vanzan deposition. We understand the narrow topics to constitute the following: the parties' claims, allegations, defenses." Yeah, so they're going to narrow all of that stuff. Defendants narrowed proposal Blake Lively's allegations in 29 of her second amended complaint that she obtained the communication cited in her pleadings in connection with a lawful subpoena. We will produce a Rule 30b-6 deponent to testify on topics 1 through 3, 6 to 11, and topics 4.5 as narrowed, subject to the usual deposition objections such as attorney-client privilege, etc. The following individuals will participate in person: Margarita O'Donnell, Naomi Bates, and Justine Harris. John Fedorov will participate via video conference. We ask that you provide us with the instructions for the video deposition platform and other sign-in details as soon as possible. Since we do not have that information, please let us know if there is anything further. See you then. So that was at 9:02, and then at 10:15, they write again to Kevin, "We've just reviewed your motion to compel, which we quite surprised to receive." Which we were quite surprised to receive. As you can see from the below, we accepted your narrow topics and confirm that Vanzan will produce a corporate designee on Tuesday, as we had told you in person to your email from earlier today. We also told you during our video meet and confer on September 24th that we were producing a corporate designee. While I've only had a chance to undertake a cursory review of your motion considering the hour, it appears that you are raising an issue as to a time period objection that we listed amongst a host of other objections in papers that were timely served yesterday. In your email this morning, you did not raise any issues regarding this objection, so we've had no meet and confers or discussions on this topic. If you had a concern about what our objections and responses said about the time period, you have an obligation to raise those with us. Your motion to compel is the first time we are hearing anything about this issue. Regardless, as you know, under the federal and local rule, had we wished to impose the limitation on what the corporate designee would testify to outside of privilege, we would have needed to move for a protective order, which we did not do. So you are going to testify about the time period beyond. So then why did you write it in every single thing? It seems like they're just playing both sides of the fence. Like they're saying one thing in all of the papers, but then in this email, they're saying something totally different. So at this point, you filed a motion to compel a Vanzan corporate designee to testify on a topic for which we already told they would appear and testify about. Maggie's email below, as well as her email from this morning, made it crystal clear that we were producing a Vanzan corporate designee, and she told you earlier today that we would respond to your email either today or tomorrow morning regarding your suggestion regarding narrowing topics 4 and 5. As such, there is no dispute between the parties and no need to waste the court's time addressing non-existent issues. As such, please withdraw your motion by 11 p.m. If not, we will file a response which makes your course of conduct clear and sets forth your bad faith conduct in not only raising an issue that was never raised with Vanzan, but also raising a dispute when you knew no dispute existed. If your motion is not withdrawn within the hour and we need to file a response, we will seek costs, fees, and other sanctions for such conduct. That's where the judge got the fees and attorney fees and conduct from, because they never actually put it in their letter. Interesting. But Wayfair was only asking to make sure. They didn't know yet. You still hadn't replied. Vanzan still hadn't replied of whether they were going to send someone, who it's going to be, as well as who it was going to be, and if you were going to answer the time. In all of their objections, they wrote they weren't going to answer anything beyond the date that the litigation was filed, which was September 27th, 2024. But now they have it in email that, okay, they're going to answer everything. All right. Then Kevin Fritz replies, in my email from early this morning, essentially last night, I demanded that Vanzan withdraw its objections to the topics. I also told you that if the objections were not withdrawn by noon, we would seek relief from the court. You failed to withdraw the objections, which never should have been lodged in the first place, especially given the court's prior ruling that Vanzan's communications with Jones Works are relevant. You attempted to bury within a host of other objections the fact that Vanzan's designee would not testify to anything predating the Vanzan lawsuit. If you are now ready to withdraw the objections, please prepare for my review a formal stipulation to that effect, and we can submit to the court to be so ordered. Sent from my iPhone. Okay, and then here we go. Oh my gosh. Then they write, this is a battle. Okay, then they write, Kevin, it seems too clear to us that your email from last night was an effort to set up a motion to compel without giving Vanzan any notice of the nature of any disagreement. We find this very disappointing and completely inconsistent with the spirit of a meet and confer and the need to be efficient with the court's resources. The fact that they can even talk about using the court's resources when they filed a fake lawsuit gets me every single time. We find this very disappointing and completely inconsiderate. The chronology and communication speak clearly for themselves. As you know, if Vanzan had wanted to narrow the scope of the topics based on the time period, we would have moved for a protective order. Similarly, if Vanzan had wanted to refuse to produce a designee based on relevance, we would have had to move for a protective order. Vanzan did neither. Instead, Vanzan has spent the time since you served your subpoena preparing a designee to address your deposition topics. We told you on September 18th that we would provide a corporate designee on September 30th. And we told you again on September 22nd during our meet and confer that we would produce a designee to testify on the topics, as we had reached out to discuss the topics in advance, as is the practice under the amended federal rules. Then we followed federal practice and asserted Vanzan's objections and responses on September 24th. How can you say that you weren't objecting when you sent your objections and responses and every single response was an objection? It's like they're doing one thing and saying another thing. It's just like baffling. I would be spinning in circles dealing with these people. This ran the gamut, as they always do, and as no doubt your clients have done in this case. For example, we asserted objections based on privilege, work product, relevance, duplicity, and burden, and yet we repeatedly told you we would produce a designee for all topics. But if you're going to produce a designee for all topics, but then they're not going to answer any questions on those topics, what's the point of producing a designee to answer topics that they're not going to answer on? And when we list such objections to your specific deposition topics, we said at the end that regardless of objections, we would produce a corporate designee to testify to that topic and noted no limitation. This stands in stark contrast to our response to your document requests, where we listed objections and never once stated that documents would be produced. We want to be very clear. Since your motion and email seem entirely focused on the time period, you never raised any concerns about the time period objection with us. Your 1238 email purposefully buried the issue in a vague demand that Vanzan withdraw all its objections, including privilege. At the same time, your email outlined multiple specific issues. We spent the day focused on the specific issues you raised so we could get back to you when we said we would and try to reach an agreement on those issues. We acted in good faith in trying to address your 1238 Why are they so mad that he answered at 12:38 when they sent him the first email after 10 p.m.? He only answered an hour and a half after their original email. And now they're so cheesed about the 12:38 email. It's like, what was the deadline for emails? Midnight? Are you guys Cinderella here? What's going on? Where's your glass slipper? I'm so confused. Anyway, we acted in good faith. Yeah. Vanzan acted in good faith, guys. You had multiple opportunities to ask about the time period. You did not do so. The first we heard about the time period issue was in your motion to compel, which we were shocked to see. If you had raised the issue, we would have gotten back to you with a response reiterating our same position, and you would not have filed your motion. In any case, there is no dispute. As Vanzan has said repeatedly, we are producing a designee to testify about the topics consistent with the topics as they are narrowed by your mutual agreement. Blah, 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 blah. We reiterate your request that you withdraw your motion. There is no dispute, and it is a waste of the court's time. You have until 8 a.m. to do so. If you do not, we will fire a response, point out your bad faith conduct to the court, and request fees, blah, 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 blah. Well, you got that, Vanzan. So they write this huge thing to Kevin. And what's so funny is this email, you don't see where it's coming from. Oh, look, at 12:23 a.m. it looks like from Federal. Oh, look at that. At 12:23 a.m. this email was sent. But yet, how many times did they talk about the 12:38 email from Kevin Fritz? That is jokes on itself. How hypocritical do you have to be? That's kind of crazy. But then Kevin Fritz wrote, John, Vanzan's written objections state that Vanzan will only provide information for each of the topics starting from on or about the filing date of the Vanzan lawsuit, which is September 27th, 2024. Please let me know the good faith basis for that objection. Upon receiving your written objections, we asked you to withdraw them by September 25th at noon. You failed to do so. We also asked you to meet and confer the same morning. You failed to do so. If Vanzan is now finally willing to withdraw its objections, please prepare a stipulation to that effect, which can be so ordered, thereby resolving the motion. That seems pretty normal, right? Like, I think Kevin Fritz at that point was just like, bruh, you said what you said. We've gone over it. We just went over it. It's all objections. They objected to every single topic. So either withdraw your objection saying that you are going to talk about it, or it's done. It's a wrap. We're not pulling nothing from the courts. And in the last email here, and now this was on at 8:18 a.m. So just literally 30 minutes after Kevin Fritz sent that email, they write, we told you on multiple occasions that we are providing a Vanzan corporate designee to testify about the topics in defendant's deposition notice and impose no limitations with the exception of privilege. Your request to withdraw all objections, including privilege, which you have no right to even request, is not something any parties have done in this litigation, and you know full well is made in bad faith. We will file our response with the court, and we will make our designee available Tuesday. If you no longer wish to take this deposition, please let us know today by noon, so we don't waste further time and effort in this matter. We accordingly reserve all rights to seek sanctions based on defendant's conduct here. I'm only laughing because, like, why would they not want to now depose you? But he's not asking, and he even said in his email, he's not asking you to withdraw the privilege. It's all about the time period. Duh. And now this is the last email that was sent from Kevin Fritz. And this was this morning at 8:26. And it says, please let me know today which witness will be testifying about which topics. You are free to make whatever privilege-based objections you deem appropriate. We reserve all rights in that regard. I am reiterating any request for you to set forth your good faith basis for Vanzan's objections that no information predating its September 27th, 2024 lawsuit will be provided. It seems pretty clear to me that the Wayfair people just wanted to know before they sit down with Vanzan, okay, all of these people are coming to the deposition, but which person is going to be talking about which topic, as well as why are you not willing to talk about anything predating September 27th, 2024, the date that Vanzan litigation started, the fake lawsuit with the sham subpoena. But then the judge came back real quick, guys, and just completely denied the motion to compel. Now, I did see another lawyer do a video on here where they said that she suspected that Wayfair knew that the judge was going to deny the motion to compel because it was like an early stage. Usually that happens kind of after the deposition. But I don't really know. I don't like it. I think the judge should have definitely been a lot more clear in his ruling, first of all, and put in that Vanzan needs to answer questions prior to September 27th, 2024, like what he's been doing with all the dates when it comes to the smear campaign, et cetera, et cetera, et cetera. Vanzan is literally in email saying one thing, but then in their responses and objections saying something totally, completely different. It's like running around in circles with these people. And at least we're getting something on Vanzan, and we know their deposition is on September 30th. And I can't wait to hear them try to get their way out of this. This is the moment that we've been waiting for, is for Vanzan to finally come to the front, please. And I noticed that on those Vanzan, out of all those Vanzan people, Ryan Reynolds and Blake Lively aren't going to be there. I wonder why. It's because of you, Ryan, that we're here. It's because of you, Blake, that we're here. You illegal, unethical, immoral, corrupt monsters. Anyway, guys, I'm just looking at the time, and I'm not going to be able to get to everything else filed in the other courts. Okay, so this video is all going to be Vanzan. If you like, in the next video, I'll have right after this, it's everything else filed and all the other stuff going on, including your comments that I have queued up. Okay. So this whole video was just Vanzan, but that is everything. That's literally everything from start to finish of everything that happened. Okay. Let me know how you're feeling about this. Drop your comments and let's get into it. I'll talk to you soon and I'll see you real soon. I love you. Bye.